2, 1.
Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the Tennessee Court of Appeals. We appreciate both of you agreeing to participate in this oral argument via Zoom today. We've had a few glitches this morning and hopefully we'll get all those resolved. But anyway, we certainly appreciate you participating. Before we get started, though, I'd like to introduce your panel for this morning. We have Judge Kenny Armstrong from Memphis, Judge Christy Davis from Knoxville, and I'm Steve Stafford from Dyersburg. I want to remind everybody that we will, first of all, that this argument is being transmitted via Zoom. It's being live streamed. Also want to tell everyone that we will be using the same protocol and procedure that we would be using as if we are in the courtroom. So, Ms. Tebner, anything we need to take up before we get started?
I know, Your Honor.
All right, we will hear from the appellant.
Your Honor, if it's okay, I'll call the first case.
Yeah, I'm sorry. I'm getting a little confused this morning.
James David Lucy versus Leah Kiele New Ling Lucy.
All right, now we'll hear from the appellant.
Good morning, Your Honor, and may it please the court, I'm Jim Powell from the Weakley County Bar. I'm here today. I represent Mr. Lucy, who is the appellant in this matter. We have one issue before the court today, and that issue is whether the trial court erred in considering all of the factors that were relevant to award Mrs. Lucy spousal support in the amount of $750 per month. It is our position today that the judgment to give her the $750 was clearly erroneous given the income of the various parties. The testimony at court was fairly clear that while Miss Lucy has need, and we agree that she has need, we don't dispute that. However, we do dispute that Mr. Lucy has an ability to pay support, Your Honor, based on the factors. Mr. Lucy testified at trial, and it was undisputed that his income was approximately just a shade over $4,000 per month. His expenses through his testimony and proof shown that there was a deficit, a small deficit, even at that. His expenses were $4,000 and some odd dollars, just a little bit above what his income was. Those facts were undisputed in the record at trial. Mr. Lucy testified that at the trial, and we'll say it's undisputed, Your Honor. He is a worker for.
Let me ask you a question, Mr. Powell.
Yes, sir.
You've used the term undisputed several times here, and was this evidence actually undisputed? I know, obviously, from your brief, and it'd be the same way that any practitioner would want to write it. You're taking the best possible evidence in your light. But was all this evidence disputed? The expenses, income, and all those things?
I was not the trial attorney, Your Honor, but in reading the transcript from the trial attorney, I believe that it was. If you read the trial transcript, I believe you'll see that there were some questioning about his expenses, but I believe it was undisputed. There was no proof that he was being dishonest. The court in its findings in the order did not find that he was not credible. So in my opinion, Your Honor, yes, sir, it was undisputed. You may not find that it was, but I believe that it was. Also, it was testified to at the hearing, Your Honor, that Mr. Lucy had worked a considerable amount of overtime to reach the income that he had had previously. And in response to that, the appellant's attorney at the time, Miss Rebecca Beasley, put on a lady by the name of Rebecca Bolin, who was a human resource analyst, 3 with the Tennessee Department of Children's Services, where Mr. Lucy worked. She testified that Mr. Lucy had a lot of overtime in the previous year because The agency was short-staffed. They didn't have enough people to cover. He was having to go to a lot of different counties and cover. She testified at trial in this, though, that he would not be receiving any more overtime, that the facility or that the Department of Children's Services was fully staffed, that he had not received any overtime since March of that year of 2020, Your Honor. She further testified that he would not be getting a raise because of budgetary constraints on the state, as I think we can all understand. She testified further that his income is what it is and wouldn't be any more than that. And again, her testimony, if you read the record, in our opinion, Your Honor, it was undisputed also. There was no dispute that that was true. So,
excuse me for interrupting. Your adversary says that there are several expenses that were listed on your client's affidavit that simply don't exist anymore by nature of the divorce. I think about $1,000 worth. That includes a credit card bill that should be paid off by now, a rent payment that should not exist anymore, and a couple of payments for an adult son. What is your response to that?
Yes, Your Honor. To be quite frank with you, as I said, I didn't do the trial. I'm working with the facts that were had at the trial. I've read Mr. Hamlin's brief. I can't honestly say whether that's true or not. I want to be real frank with the court because, as I said, I wasn't there at the trial, and I'm just dealing with the facts that were available at the trial.
Let Mr. Powell, let me follow up on Judge Davis's question just a moment. Obviously, the evidence that Judge Davis mentioned was introduced at trial, was it not?
Yes, sir. Yes, sir. I think yeah, absolutely.
So what did the trial court find regarding those issues?
Your Honor, it's very difficult. I'm certainly not trying to attack the trial court judge, but if you read the order, it really makes no findings as it relates to that. All it says is that he considered all the relevant factors. It doesn't go into any depth as to what he decided, any credibility issues, anything like that. That was part of our brief to Your Honors there today, is that there were no specific findings of any facts in the order or anything like that. So I don't know what the court, quite frankly, found about all of that, other than to say that they made no specific findings of facts as it relates to that.
So where do you believe that leaves us today?
Your Honor, I believe that it leaves you with quite frankly, with two options. One of those options is to send it back to the trial court to ask to make specific findings of facts and place those in an order. However, we believe, Your Honor, pursuant to Norris v. Norris, a 2015 case, Your Honor, we believe that there's enough evidence in the transcript, technical record, and exhibits that this court would be capable of making its own determination regarding where the preponderance of the evidence lies, quite frankly.
I understand that's your position, but let's go a little further with that then. Judge Davis has mentioned some very important questions that we don't know whether the trial court decided one way or the other. How do we deal with that when we have to take credibility into consideration? So I understand from an efficiency point of view what you're suggesting, but I don't know how we do that. So if you could enlighten me, that maybe that would help.
Well, Your Honor, the only thing that I'm saying today, Your Honor, and maybe I'm erroneous in my thought process, which happens occasionally, but there's enough proof in the record to show, Your Honor, that, you know, there were things in the record, such as Miss Lucy testifying that she made $11 an hour. And then if you look in the transcript, she says in her testimony that she could go right then and make $15 an hour at Tyson's in Union City. And when asked why she didn't want to do that, she said, because it's cold there. But she also testified she had no physical limitations that would keep her from working there. She just didn't want to. when asked why she didn't want to go back to school, or why she didn't go to school, she said she'd been in school for a little while. She just didn't want to. And her thought process was in the testimony was that Mr. Lucy ought to just help her. She shouldn't have to worry about doing that kind of thing. And so maybe I'm not answering your question. You're asking me something that, quite frankly, I don't know, Judge. I don't know how you're going to make a decision based on the order from the court.
Let me ask you, Mr. Powell.
Yes, sir.
You argued about this witness that says that in the future, Mr. Lucy's income is going to be different. We know that at the time of trial, his net was $4,000 a month. Without receiving overtime, is there any proof in the record about what his net income is going to be in the future?
No, sir. I think maybe I misstated that, Your Honor, and I apologize if I did. His income had been greater in the past due to the overtime. The $4,000 number was his income without the overtime.
Okay.
So maybe I misstated that or misled you. I didn't intend to, but.
And that's his net income, not his income. Is that right?
Yes, sir. That's
without
right.
His net.
Yes. Yes. But going back to Justice Stafford's question, I don't know how you're going to make a decision based on this, quite frankly, given the order, because the order does not meet the specifications as far as there's nothing in the record, we believe, that would show, or in the order that would show how he arrived at the decision to award alimony based on all the testimony. But that's our proof, Your Honor.
All right. All right. Thank you, sir. We will now hear from the appellate.
Good morning, Justice. I'm David Hamblin from the Obion County Bar. I think I can answer the justice's question about how the judge decided the alimony question. All you got to do is look at the numbers. And all you have to really look at is the Mr. Lucy's affidavit of assets and liabilities and his expenses. Those are set out in his affidavit. They are uncontroverted. The proof is that the wife earns, as of 2020, she would earn $28,000 gross per year. We determined that.
Let me ask you a question, Mr. Hamlin. Both Mr. Powell's used the term undisputed. You said uncontroverted. If it's all undisputed and uncontroverted, then why are we all having questions about why the chancellor did what he did? And
well, that's because Mr. Lucy appealed the case. That's the reason y'all got it. But that is
part of it. But I'm trying to figure out what proof he believed and what proof he did not believe.
Well, all right. Look at Mr. Lucy's affidavit of expenses and income. That's the only thing we really need to examine. And his own testimony sworn to in his affidavit is that he made $52,000 gross earnings from his job at the department, and he made $7,000 and change from the guard. That's $59,968.82 gross earnings. That's in his affidavit. You look at the next thing, he says, I made $4,010 net. That's from his affidavit. That's sworn to by Mr. Lucy. And I'm not going to argue the overtime. I'm not going to argue whether he's made more money in the past. I'm going to use this $4,010 that he says he makes. And we'll use that number. Now, the wife's income testified that she used 2019 tax return on her affidavit, which was a little bit off because she had worked a bunch of overtime in 2020. And in the first 6 months from her testimonies, she made $14,079 year to date, which was through June. And so you double that, she made about $28,000 in 2020. So now let's look at the expenses. No one disputed Miss Lucy's expenses, $2,702. We're not going to accept Mr. Lucy's expenses because he says they're $4,028.
Well, Mr. Hamlin, let me ask you. Well, did we lose Judge Stafford? Let's see here.
I should be here, I hope.
Okay.
Yeah,
All right. I see you now. Where do we find in the order or in the record the trial court's determination about Mr. Lucy's legitimate expenses? Do we know what the trial court found in that regard?
I don't know just if the order included the letter that the chancellor issued whenever he took the matter under advisement. I'm not sure that's part of the record. I don't have that in front of me, but the order itself says that based upon the testimony of witnesses and upon the entire record, which included the transcript, it included the testimony, it included the exhibits, he took that all under consideration. And I understand you're asking me, did he spell out sentence by sentence, word by word, who he believed, who he didn't believe, what facts he took into consideration? He did not set that out in his order, but he said that based upon the complaint, the counter complaint, the testimony of witness, and the entire record, he determined that the alimony was appropriate. And so the way he did that was follow the testimony. And if you follow the testimony, we actually pointed out to the chancellor in the trial that Mr. Lucy's expenses were not $4,010 per $4,028 per month, because he.
Excuse me. Does the order for alimony, what length of time is that for? I can't tell from the order.
In futuro.
Okay, so it's 750. There's no limitation on her remarrying or anything like that?
Well, alimony in futuro would include opportunity for him to come back and ask the judge to modify that if her circumstances changed, including marriage, living with someone in a third-party relationship, or earning extra income. And that would give him the opportunity to modify that.
So as of right now, it's in future. It's just 750 for
forever,
foreseeable future.
Yeah, that's right. And so what I was getting to, the judge gave him the house, which he requested. And of course, he got the mortgage that goes with it, $672 a month. But in his affidavit, he listed his expenses, $672 for the mortgage. And then on the next page, he said, I still got a $300 a month rent payment. Well, that's, that he was renting something for $300 according to the testimony during the trial. But when he got the house, the rent went away. So I know that's $300 that we don't have to count. And then he claimed this Marcus credit card was $410 a month. Well, his testimony on page 60, he said he only had 2 payments left on that credit card. So that would eliminate $410 right off the top 2 months after the divorce is finalized. And then he also testified that he was paying car insurance on himself, his wife, and his son. And he acknowledged on page 81 of the transcript that he could not carry insurance on his wife after the divorce. And of course, we all know that, you're not obligated or not required to support your adult son. And so I used the car insurance of right at $300. I think it was $296 or $289. And I just divided that by 3 people. And so I took off the expense he was claiming for all the car insurance for his wife and his son, which is about $200 more. And then on the last page of his affidavit, he said he had $100 expense for his son just to help him out. When you add all that together, the $300 rent that he doesn't have, the insurance that he's not obligated to pay, the Marcus and his expense for his son, that's $1,000 a month that he really does not have actual expenses for. And so he said he had $4,000 in expenses. You take $1,000 off, he really only had $3,000. He said he made $4,000 a month. That's $1,000 extra every month. And that's what the judge had to look at. He had to look at the wife's need, which they've acknowledged that she has the need, and he had to look at the husband's ability to pay. And the husband's ability to pay is clearly shown when he has an excess above his expenses of $1,000 a month net income. So I don't believe there's any dispute about the numbers. No one objected whenever we determined the net income for Miss Lucy. No one objected to the expenses that she claimed. No one objected to the expenses that Mr. Lucy claimed, except Miss Lucy, whenever she pointed out to the court and through her testimony that all of these expenses for these people who he wasn't obligated to pay for, and all the rent, that's clearly in the numbers. So I think all you really have to look at is the affidavit of Mr. Lucy to determine that he does have sufficient income and he does not have income that expenses that eat up that income. If that were all taken as true, if he had $4,000 in expenses and $4,000 in income, and the court is required to determine that he has the ability to pay, I can't see any court making that determination based on those numbers. But I think when you look at the transcript and listen to the evidence that the judge listened to, he understood that we were taking off $1,000 a month from his expenses because those expenses were unwarranted.
Mr. Hamlin, do we know from the record when his obligation under the lease would end?
I don't know that he was renting on a lease period. I don't think the record actually says whether it was a lease or a month-to-month rent. That's probably not in the record anywhere. I don't know that anybody asked him that question, so I can't answer your question. If there was, I don't even know that there was a lease. But I think the only testimony in the record was, and I think that might lead us to believe it was a month-to-month deal, because I think in the record it says he was renting a room in a lady's home, is what I think. I remember reading in the record and listening to it court. He just had one room out of a house that he was staying in. I'm not sure he actually would even have a lease for that kind of a proposition. But the record does not indicate whether it was a lease or a month-to-month rent.
Okay.
So looking at Mr. Lucy's argument, he says it's an abuse of discretion because it would create a substantial deficit in his income. That doesn't bear out from the numbers. He argued that Mr. Lucy doesn't have any overtime anymore. We're not even talking about overtime. We're using the numbers that he gave us. His present income, forget the overtime. That's not even an issue anymore. We're using his $4,000 a month that he says he makes. And, you know, you can do a de novo review of all this if you want to, and you can go back and look at these numbers and you can read the transcript. And when you do, you're going to come up with the same numbers. None of that's going to change. You're going to come up with the same subtraction and addition. It's just mathematics. Whenever you look at the numbers and you say one person makes less than $2,000 a month, another person makes $4,000 a month.
One other thing, Mr. Hamlin, in connection with the debt that Mr. Lucy was ordered to pay, is the payment on those obligations included in that $3,000 a month in expenses?
Yes, sir, they are. And if you look at Mr. Lucy's affidavit, he actually requested that debt. He said, I'll take this debt. He didn't ask the judge to allocate the debt. This is not something that the judge made him pay in lieu of making Miss Lucy pay part of it. When you look at his affidavit, he says, I'll pay the Marcus credit card. I'll pay American Eagle. I'll pay AFES credit card. I'll pay Citibank. I'll pay PayPal. I'll pay my student loans. All of those numbers are in his affidavit, and he agreed to pay those, and that is included in his total monthly expenses of what he claimed it initially to be $4,000, and which we think now is $3,000. But those are included in his, all of his expenses are included in that. I believe that the court was acting properly whenever it considered all of the factors in the TCA 36-5-121. I went through that in my brief, and there's nothing earth-shattering or something that would be that the court would think either way for either side. They're really not conclusive as to the alimony, except to really show that the alimony was appropriately awarded, because those factors are coupled with the numbers bear out the final decision of the court to say that Mr. Lucy should pay the $750 a month. And we submit that that was a proper decision, and we'll stand by that.
Right. Thank you, Mr. Hamlin. We'll now hear from Mr. Powell in rebuttal.
Your Honors, thank you. Mr. Hamlin draws a lot of conclusions that are not in the record. It's certainly not in the order. Mr. Hamlin doesn't mention that Mr. Lucy in the testimony was trying to take all of this debt to ease the burden on his wife, knowing that he could not pay any more than that. He took the house. Both parties wanted the house. Both parties asked for the house in the divorce, if you look at the record. The problem is that the house is worth, the value of the house, and which is undisputed also, is about $10,000 upside down. Mr. Lucy have to try to sell the house. We'll have to try to sell the house, and then we'll have to just assume that other debt somehow to pay it off. He will either have to do that through credit cards or some kind of a loan or something like that in order to pay the deficit on the house. It's not in the record, so I'm not going to argue it today, but I know that's the position that he's taking. And if you look at the record, he agrees to take those debts because he wanted to ease the burden on Miss Lucy. He had no anticipation that she would get $750 per life for the rest of her life or until she remarries. So we believe that Mr. Hamlin is making all kinds of conclusions here that are not in the record. And quite frankly, pursuant to 52.01 in the Rules of Civil Procedure, all actions tried upon the facts without a jury, the court shall find the facts specifically and shall state separately in its conclusions of law and directing. We had a hard time, quite frankly, with this appeal, with the record, because we don't know how the judge reached that decision. We have no idea how he reached that decision given the incomes. Mr. Hamlin wants to talk about, well, we just want to deal with the net pay. We also want to say to the court, if you look at Miss Lucy, what I mentioned before, that she's testified that day that she could go immediately and get a job at Tyson's and make $15 an hour, which was $4 more an hour than she was making at the time, which would equal $160 per week. And then if you multiply that by by the month, she could have made $720 more per month if she chose to, but she told the court and answered very clearly that I'm not going to do that. I don't want to do it. There's nothing physically that keeps me from doing it, but I'm not doing it. Mr. Lucy ought to have to pay. If you look at the records, you'll see that. So given the record in this, Your Honor, we've requested that the court overturn this decision or send it back to clear it up or whatever, but we appreciate your time this morning. Thank you.
All right, gentlemen, we certainly appreciate your argument. We'll take this matter under advisement and we'll endeavor to get you a appellate opinion as quickly as possible. We appreciate Mr. Hibner and the AOC staff and all their efforts in making this Zoom argument possible. Mr. Hibner, if you will recess court until the call of the next case, please.
This honorable court is now in recess until 10 a.m.
Thank you, gentlemen.
Thank you, Chancellor. Yes.